I'll start with the first. GR number 203335. Jose Jesus M. Dicini Jr. et al. Petitioners versus the Secretary of Justice et al. Respondents. With companion cases, there are 14 petitions consolidated into this decision. Collectively known as, of course, the challenges to the cybercrime law. The court partially granted the reliefs sought in the 15 consolidated petitions challenging the constitutionality of Republic Act number 10175, the Cybercrime Protection Law. The court, through Associate Justice Roberto A. Abad, with Justices Velasco and Perlas Bernabe taking no part, declared as unconstitutional sections 4C3, Section 12, and Section 19 of Republic Act number 10175. Section 4C3 penalizes the posting of unsolicited commercial communications. Section 12 authorizes the collection or recording of traffic data in real time, while Section 19 authorizes the Department of Justice to restrict or block access to suspected computer data. The court also ruled on the constitutionality of online libel when it further declared that Section 4C4, which penalizes online or cyber libel, is not unconstitutional with respect to the original author of the post, but unconstitutional only where it penalizes those who simply receive the post or react to it. The court further declared that Section 5, which penalizes anyone who aids or abets the commission of cyber crimes and anyone who attempts the commission of cyber crimes, is not unconstitutional in relation to the commission of the following cyber offenses. A. Illegal access under Section 4A1, illegal interception under Section 4A2, data interference under Section 4A3, system interference under Section 4A4, misuse of devices under Section 4A5, cyber squatting under Section 4A6, computer-related fraud under Section 4B1, computer-related identity theft under Section 4B3, and cyber sex under Section 4C1, but unconstitutional only in relation to the offenses punished by 1. Child pornography under Section 4C2, unsolicited commercial communications under Section 4C3, and online libel under Section 4C4. The court also ruled that Section 7 on prosecution under the revised penal code as well as under the cybercrime law is unconstitutional as far as it authorizes the prosecution of an offender under both Section 4C4 online libel and Article 353 of the revised penal code on libel, and also where it pertains to Section 4C2 child pornography for being in violation of the constitutional prohibition against double jeopardy. Okay? That is all as far as cybercrime is concerned. I will move on to the next item. Next item, GR number 210245. Bayan Muna Representatives Nery Javier Colmenares and Carlos Izagani Zarate et al. Versus Energy Regulatory Commission, ERC, and Meralco. Consolidated cases with Nasicor versus ERC and Meralco, and the counter-petition of Meralco versus the PEMC. Acting on the urgent motion for extension of the TRO and or preliminary injunction filed by the petitioners, seeking to restrain respondents ERC and Meralco from implementing the rate hike during the pendency of these petitions, and to enjoin the imposition or collection by respondent generation companies or GenCos and suppliers of the generation charges subject of these petitions, the court today resolved to do the following. 1. extend the existing TRO for an additional 60 days from its expiration or until April 22, 2014. B. Grant a temporary restraining order effective immediately and for a period ending April 22, 2014, enjoining the generating companies, specifically Masinloc Power Partners Company Limited, care of AES Philippines, San Miguel Energy Corporation, South Premier Power Corporation, First Gas Power Corporation, and the National Grid Corporation of the Philippines from demanding and collecting the deferred amounts representing the affected costs based on the matters raised in Meralco's December 5, 2013 letter. And C. Grant a temporary restraining order effective immediately and for a period ending April 22, 2014, enjoining the Philippine Electricity Market Corporation or PEMC from demanding and collecting the deferred amounts representing the affected costs based on the matters raised in Meralco's December 5, 2013 letter. Okay, that ends the second item. I have one more item before I will take some questions. Third item, GR number 210922, Development Bank of the Philippines versus Commission on Audit. The court granted a TRO effective immediately and until further orders against the directive to return the benefit subject of the COA's notice of disallowance of DPP's Early Retirement Incentive Program 4 or ERIP 4. You may recall that this case involves the determination of what is covered under the prohibition on supplementary retirement plans of government agencies and the application of the receipt in good faith principle in Nazareth versus Villar. That is, benefits received in good faith need not be returned to the government. This involved a notice of disallowance involving the amount of over 747,174,594 and proceedings that were raised to the Commission on Audit and affirmed by the Commission on Audit. The DPP has now raised this matter to the Supreme Court. The Supreme Court granted the application for TRO on the basis of the possible good faith of the petitioners.